Hello, everybody. This is Doug Poneck of Ecamilla and Poneck. We're here for the board governance training. As the board lawyer, I'll be talking to you about what the board member responsibilities are and also as a board as a whole. We'll be focusing on three areas: legal governance, proper governance, and effective governance. The focus will be mostly on legal governance, but I'll wrap up with the latter two near the end of the presentation. So let's start with legal governance. When anyone sits on a board, it's important to remind everyone what power the board has, where the power is derived from. And so in your case, you have federal law, for example, the Workforce Innovation and Opportunity Act, which establishes the requirement for the development of local workforce development boards across the country. Then we have our Texas law, Workforce Investment Act, which has provisions regarding the creation and administration of local workforce development areas and boards. And then finally, we have administrative rules that come from the Workforce Commission, which address the formation and responsibilities of local workforce development boards. As a board member, each board member has three duties of responsibility. There's the duty of care, duty of loyalty, and duty of obedience. The duty of care is to advance the entity's mission and participate actively in the governance and oversight of the board. So attending board meetings, reading the board materials, being prepared for board meetings, and participating actively in the board meetings is one of those responsibilities. Duty of loyalty means to always act in the best interest of the entity. So whenever you find yourself in a situation where you may have a feeling, if nothing else, that there may be a conflict between what you're doing for this board and some other responsibility you have, it's important for us to address that and make sure that you're fulfilling your duty of loyalty to this entity. Finally, the duty of obedience means that you'll comply with all the applicable laws, regulations, policies consistent with the board's decisions. So it is important to know that you're a member of a board, and so you are to follow the decisions of the entity through the board and fulfill the duty of obedience by doing so. Common question often arises with one's service on a board. What liability does an individual have if something goes awry with regard to a decision made by the board? A board member may not be held individually or personally liable unless the board member's conduct stems from one of these three things, which I've highlighted in red to really underscore how these are things you do not want to be accused of engaging in. Official misconduct, willful disregard, and gross negligence. Official misconduct means intentionally or knowingly violating a law while acting in an official capacity. So if you make a mistake, that's not rising to that level. But if you know better and there's evidence to show that you knew better, and despite knowing better, you still violated the law, then you could be found individually liable for having engaged in official misconduct. Willful disregard, again, is knowing better and then willfully deciding not to follow what the law requires. And then gross negligence is not just mere negligence, but it is having no concern at all about whether or not you're acting appropriately. TWC regulations also have rules regarding conflicts of interest, and they get more specific and more restrictive still further. In this case, as before, a board member may not vote on anything that would give the board member a direct financial benefit or give the board member's immediate family a direct financial benefit. And the board member can also not vote on matters regarding the provision of services by the board member or an entity the board member represents, just as we discussed in the prior slide. But further on, it says no board member may participate in a decision in which the member has a direct or indirect interest, particularly a financial interest, which is in substantial conflict with the discharge of duties of the board. Defining what a direct or indirect interest can be tricky. And so my recommendation is that if anybody feels that they may have a direct or indirect interest in a particular vote, that they again voice that in advance. And then assuming that there is such an interest, there has to be a showing that it's in a substantial conflict with the discharge of the duties of the board. My advice to all board members is to avoid taking votes on anything involving a direct or indirect interest, and not quibble about whether or not it's in substantial conflict with the discharge of the duties, because there is risk involved in some independent body or a court ruling that it is in substantial conflict. So why invite that scrutiny? As before, a board member shall avoid even the appearance of a conflict of interest, and what you're required to do is to disclose any interest you have to the board chair, so that these issues are addressed in advance of any votes. And even if you've done that, when you see an item on an agenda or a committee or a board meeting, and it triggers in you that feeling that there may be a conflict for you, my advice is to voice that to the board chair and the CEO in advance of the meeting, so that, again, that can be vetted appropriately. In the end, though, if a matter gets to a board discussion or a committee discussion and a vote, and you are someone who has got an interest in the matter that is separate from your interest as a board member, the proper process for you is to disclose that as you would have by discussing it with the board chair, and then refrain from any discussion on the matter, and then abstaining from any vote. Depending on how serious the conflict is, it may be advisable to step out of the room, but typically just abstaining should meet that requirement. Now we're going to talk about the Texas Open Meetings Act, and since you are a quasi-public entity that adheres to the Open Meetings Act and must adhere to the Open Meetings Act, it's important for us to understand the requirements. First of all, meetings must be open to the public unless authorized by law. And those exceptions involve consultations with the attorney, discussing real estate, personnel items, security matters, and so forth. Legislature has determined for good reason that those kinds of discussions would not be in the interest of the entity or the greater public if those had to be had in open session. The meeting notice has to be publicly posted for at least 72 hours before the meeting, and it has to give adequate notice regarding the date, hour, place, and subject matter of all meetings. The more important the matter, the more adequate the notice needs to be. So, for example, if you were to talk about the CEO evaluation or contract, it would be inadequate notice to just put an item on an agenda that you would be discussing personnel. So depending on the importance of the matter, there has to be care given to giving more specific notice to the public. And there's always a tension there, because you don't necessarily want to draw too much undue attention, but you do want to give the public fair notice of what's going to be discussed. And typically, I will work with your staff to develop the adequate notice. So what is a board meeting? And these are some shorthand rules. A board meeting is a quorum of the board or a committee gathering to discuss the entity's business, and that then triggers the notice requirement that we just discussed. So you cannot have a meeting of the board or a committee in secret, unposted. You cannot, if it's going to discuss the entity's business. It is theoretically possible, of course, for a quorum or more of a board to meet in a social setting, to watch a football game, what have you. But the moment that that group starts talking about the entity's business, then that's a meeting, and you have to make sure that it's been posted. Now we're on to video conferencing under the Open Meetings Act. So as you know, during the pandemic, the governor did not require boards to meet in person as part of his emergency orders, and Zoom meetings were instituted and permitted, and they were very convenient. However, once the governor determined that there was no longer a need to have that kind of flexibility, we now have to revert back to what the law is required from before. So in other words, there is no new law that allows more video conferencing than we had previous to the pandemic. So if a board wishes to have video conferencing, it has to still have a quorum of the board physically present in order to conduct the meeting, and additional board members can be participants virtually. But as I said, it requires a quorum to be physically present in a location. The presiding member also has to be physically present. So if the board chair can't be there in person, then the vice chair has to run the meeting in person. And if the board chair still wishes to participate remotely, the board chair can do so, but the board chair will not be remotely presiding over the meeting. The meeting location in each remote location must have two-way audio and video communication, and the participant's face must be clearly visible and the voice audible to all. So there is more restrictive requirements for the conduct of video conferencing, unlike those that we had during the pandemic. Walking quorum. So, it is a mistake for folks to think that if board members meet in less than a quorum and never trigger a true quorum, but they have small group discussions among a number of small groups, and then they share each other's discussions again outside a board meeting, and those numbers of people meeting outside a board meeting add up to a quorum, that would be considered a walking quorum, and that would be in violation of the Open Meetings Act. So it is important for any discussions that are had by board members to be at a board meeting, unless it's fairly clear that any subgroup that's meeting is only discussing things amongst itself. And there isn't an intent, by the way, for those small group discussions to get around the posting requirements. So it is okay for a small group of board members to have an offline discussion, so long as they are not a quorum of the board, and so long as they're not cross-pollinating their discussions with other board members in an attempt to circumvent the notice requirements of posting a board meeting. These rules also apply to committee meetings, because although the act has only spoken in terms of board meetings, the Attorney General has issued an opinion some years ago that has said that if most of the work essentially happens at a committee meeting and that committee meeting wasn't posted, then the matter goes to the board, and the board essentially just approves it without a discussion, then that can trigger a violation of the Open Meetings Act. So it's my recommendation to always post notices of your committee meetings just as you do your board meetings, so that we're complying with that scenario, because a committee can never know in advance whether the board will essentially just approve something without having deliberated it, perhaps out of deference to the work that the committee did. So I advise that we always post committee meetings and board meetings, and that we follow the requirements that are imposed on boards with the committees in every regard. So violating TOMA is a pretty important severe thing, can have severe consequences. So a board could theoretically approve something not having complied with TOMA, not giving adequate notice, for example, in what was posted. And if someone wishes to challenge what action a board took in that scenario, that action could be voided. It is voidable. It is not automatically void, but it can be voidable by someone challenging the action, taking us to court to challenge the kind of compliance we showed with TOMA. It's a criminal offense to knowingly conspire to circumvent the act, as I mentioned before. There should be no effort to get around the act by trying to meet in numbers of board members less than a quorum in secret or what have you, just so we don't have to post a notice. We don't want to do that. It's also a criminal offense to knowingly participate in a closed meeting that is not allowed by law, Again, there are only certain things that a board can meet in closed session for. So if it's not one of those clearly delineated things, or it's one of these secret meetings, you could be criminally liable. So my recommendation generally is, as appearances and context matter, always err on the side of posting meetings and following TOMA. We want to be known as an entity that always attempts in good faith to comply with TOMA. As part of the TOMA requirements, we have the requirement now that public comment must be heard at all meetings, either prior or during the consideration of agenda items for which members of the public wish to make comment. There was a school district in South Texas that would hold its time for citizens at the end of its board meetings. The board would conduct all its business, and then at the very end, sometimes as late as midnight or later, the public would finally get a chance to have its opinions heard, and often they were there to speak on items that were considered by the board, but had already been voted on. So a law was passed to now require all boards to hear public comment on any agenda item. And I think that is to be read as any public agenda item, not closed session agenda items, before or during their consideration. So when a board is speaking on a particular agenda item, they could theoretically have a list of folks who signed up for that agenda item and hear them at each agenda item that they signed up for. But most boards hear all public comment at the beginning, and that complies with law. Boards should also, by the way, have at least one opportunity at each board meeting to hear things that are not posted on the agenda, to hear comments from the public on things not posted on the agenda. Because the First Amendment to the US Constitution, which is mostly known for affording folks free speech rights and the freedom to associate, also gives them the right to seek redress from their governments. And one way to achieve compliance with the First Amendment is to allow for folks to speak at these meetings. So since if our board is meeting once or a month or once every couple of months, my advice is to go ahead and hear all comments, not just the ones that are pertaining to particular agenda items. The companion law to the Texas Open Meetings Act is the Texas Public Information Act. So this pertains to public documents and public information within the entity's possession, and also the possession of folks who sit on the board or third parties like myself who provide services to the entity. So any member of the public can make a request for public information, and unless there's some specific exception to providing that information, we're required to give them that information. And if it's a burdensome request, there's a schedule of charges that can be asserted. But generally speaking, it should not be a difficult process to provide the public information which it may legitimately seek. There's sometimes confusion about what is a public record versus a private record, and public information essentially is any information that pertains to the governmental body's official business. So there have been mistakes made by folks thinking, well, if I have a private computer or a private cell phone, nothing in that device can be made public or produced to someone who's seeking public information because of where it's located. Instead, the rule is, that's incorrect. Instead, the rule is that it's the information itself that determines whether it must be disclosed. Now, private information related to one's personal life that has nothing to do with the official business of the entity is not subject to the Information Act. But if you have, again, your own cell phone, your own computer, and you're having conversations with the entity about the business of the entity, if you're looking at documents or other material or information from the entity on your personal devices, all of that kind of information is subject to disclosure under the Act. If there's confusion, by the way, between whether something is indeed public or private, we have to use the Attorney General opinion process. We do not get to just withhold information unless there is a very specific opinion on the exact same scenario. And that's not often the case. So what we recommend is that if there is any information that looks like it may be responsive, but we think it perhaps enjoys some kind of protection from disclosure, that we utilize the AG opinion process and get clarity from the Attorney General. And if the Attorney General stands with the idea that no, the information does not need to be disclosed, then we can rely on the AG opinion. And conversely, if the AG says, no, this information is public, then we must disclose it. But we want to be able to point to the AG's guidance in close call situations. Now, let me end with a discussion of proper and effective governance. This will hopefully be quick and painless. So what is proper governance? Proper governance is behaving ethically. As I say here, there's no bright line measure of ethical conduct, but some simple practices will help a board, individual board members navigate issues and concerns. I've used these shorthand descriptions before, and hopefully you will find them helpful. Watergate +1, as you all may recall from history, that there was a big investigation into who knew what about what had happened during the Watergate era. That kind of scrutiny is the kind of scrutiny that anybody serving on a public board, or anybody working for a public entity, or anybody like me providing services to a public entity, we have to be prepared to answer those questions. What did you know, and when did you know it? And then the third question that you'd have to be able to answer, hopefully appropriately, is what did you do about it once you found out? So you may, for example, have been made aware of an issue that looks like it's questionable legally, whether somebody has violated the law or done something that wasn't in conformity with the law. If you become aware of that kind of thing, even though you yourself did not do this thing, then you have to take steps to make sure that you're acting out of a duty of care for the entity to protect the entity. And so you want to be able to say that you voice that concern to the board chair or the CEO or to the board lawyer so that it could be effectively dealt with without undue delay. You don't want to sit on something too long, because then you can be accused of having swept it under the rug or acted out of some other interest other than the best interest of the entity. Also, if whatever you do as a board member, you don't want to have it linger or do something that you don't entirely feel comfortable with. So I use the shorthand of pillows. You want to be able to put your head on the pillow at night and know that you did the right thing. And again, doing the right thing is not only doing the right thing, but doing it promptly without undue delay. Yard signs and front pages. Again, this is a off the cuff kind of shorthand for do those things that you would be comfortable seeing posted on a yard sign in front of your house, where your neighbors who walk by can see it and say, okay, we have a neighbor who's done the right thing here. And also, you don't want to be in an embarrassing situation, that would be on the front page. How would you feel if your conduct was described on the front page of a newspaper? You want to be able to say you did the right thing and have it be demonstrably so. When you're confused, if you're confused, use sounding boards. Use the board chair, the CEO, the board attorney. Even as attorneys, we have to research things or discuss it with colleagues to try to problem solve things that may be particularly challenging or difficult to sort through. It is completely understandable for board members to perhaps have some confusion about what the right thing is, reasonably so. So in those situations where you're not sure what you should do, consult with your board chair, your CEO, or the board attorney, because one, you'll probably get good advice on what the next steps ought to be, and you'll undoubtedly get help about let's together do the right things. but you'll also demonstrate your fidelity to the entity by having reached out rather than sat on your own and invite questions about, what your motives were. Generally, truth, accountability, and transparency in all things is best. So if you keep adherence to that, you're going to be in a much better place than trying to negotiate it yourself, perhaps making the wrong decisions. Another aspect of proper governance is adhering to chain of command. So as we discussed at the beginning, state law and TWC rules outline the roles of boards and their staffs and how important it is to follow the rules. Good governance requires adherence to those roles, because there is no law that says that a board member can act individually on their own to act on behalf of the entity. There are extreme examples, perhaps, of a situation where, let's say, the whole organization is a corrupt organization and only one board member stands apart saying, I've got to bring an end to that corruption. That extreme situation in my 30 plus years of experience has happened maybe once or twice. And there are ways to process through that. But on the whole, boards are the bodies that have the true legal authority to act. And so no board member should forget that whatever they do as a board member, it should be through the board. Also keep in mind that only the CEO can direct staff. And so there should be no effort made by any board member or even the board as a whole to direct staff to do any particular thing. And when it comes to directing the CEO, it should be only on larger policy issues. The CEO should be left to handle the administrative side of things. So in all things, think organizationally and act organizationally. Finally, we have effective governance, which is building upon the prior two governance discussions, legal governance and proper governance, as I've described. Of the entities that I've represented over these many years, achieving legal governance and doing that well is a minimum standard. It's one that every entity should spend its time making sure it complies with, and that's why most of this discussion was focused on that. Having proper governance, meaning doing the right thing, is also important. Even if you've got legal governance covered, if you're doing all the things that are indeed required, there are times when there are issues that are hard to determine what the right thing to do is. And so it's important, again, to have followed the steps that I outlined earlier about how to make sure you're doing the right thing. I also add this proviso of 3 buckets. There are things that are clearly going to come before you that don't require you to do anything. As you're walking into a board meeting, someone complains to you about the parking situation at the board meeting site. Sure, as a courtesy, you could bring that to the attention of someone, but no one is going to look at your duty as a board member to somehow, remedy that parking complaint. On the other extreme, you could have someone come to you and say, there is this serious sexual harassment complaint that that person wishes to make against another employee in the organization. Okay, well, that's a very clear potential violation of law. And so there is a duty on your part to make sure that it gets reported appropriately, or that at least you consult with someone in the organization as to what the proper next steps are. Then there may be things in the middle of those 2 extremes that are not quite clear about what direction you should take. My advice generally is, if it fits in that middle bucket, that we err on the side of treating it as something that may indeed be important enough to process, following the laws, following the organizational requirements, and so forth. So when in doubt, voice any concerns you have and make sure that you've done your part. And if you're told no, there's nothing to do, well, then you've checked the box. Effective governance, in my view, is probably the culmination of all of these other things that we've been discussing. And I typically would not talk to boards about this because it's not truly a legal issue, but I figured that it would be helpful to the board to hear some of this, because I do think that when boards are having to spend a lot of time on just getting legal compliance or just getting through, what is doing the right thing, and not getting beyond that, which is to say, to make sure that those things are already being done, but then being able to have the organization function most efficiently to achieve the mission, vision, and strategic planning of the organization, then you're not getting the full bang for your buck in your board service. I think it's helpful to see the organization as this ship of state that is leaving port, let's say from New York, traveling to London, and you are all the board is the owner of the ship, or at least the trustees of the ship for the community. The captain of the ship is the CEO, the staff are the folks that operate the ship and do all the things. And the public's interest is sort of the passenger on the ship. It's important to obviously make sure that the ship is well equipped, that it has the resources it needs to get to where it needs to get to, that it adheres to a schedule, that it does indeed arrive at its destination and deliver on what it intended to deliver on. It is not effective to have that ship get detoured, outside of the process that the board has approved. It is not effective for the ship to stop, mid ocean to address an issue that really didn't require such a reaction from the ship. There should be a process internally to make sure that any issue that's to be addressed should be addressed through the normal process, and that there should be confidence and accountability that any issue that confronts the organization will be dealt with appropriately, following the rules of the organization and following the laws and so forth. I have seen entities that have unfortunately spent time trying to problem solve an issue that did not require the whole organization to stop its functions, simply because folks forgot to utilize the existing processes. Anyway, the ultimate goal should be to achieve, as I mentioned, your mission, vision, and strategic planning. And if you get legal governance and proper governance under control, and those don't become troublesome issues for you at all, I think you have a much greater chance of having effective governance, which will serve everyone's interests. If you have any questions about anything that I presented today, please don't hesitate to raise those to the CEO or the board chair, and I'm happy to provide any response that may be required for any questions you have. I hope you found this helpful, and if you, again, have any questions, please don't hesitate to ask. Thanks very much, and I hope you have a good meeting.